Hello, everyone, and welcome to another episode of Legal Tech Corner. Today, we're going to talk about capacity. We will, as usually, start with the pure legal concept, and then we'll move forward with the legal tech perspective about the same topic. So, not everyone in the legal relationships has the full capacity to completely participate in binding agreements and be a legal party of it. In fact, there are four different classes that do have limited capacity to participate in such contracts. The first class is the minors. Then we have mentally incapacitated individuals. And the third category, we have intoxicated persons, and we finalize with corporations. Let's shortly focus on the category of minors. Who is minor? Minor is a person with the age under 18 years. The contracts in which minors are part are usually not enforceable against the minors, but they are enforceable against the other party. The contracts are voidable based on the minor's petition, the request, and this means that the contracts in which minors are party can be cancelled by the minors. However, there are some exceptions for various categories where the contract is still binding for the minor. The first category is the necessary goods and services. This means that if the subject of contract are the goods which are necessary for the minor, then the contract automatically becomes binding to them. As a second category, we have employment contracts, contracts related to education and training. In the third category, we have a bit broader perspective where we have all the contracts which are beneficiary for the minors and do play a role in their earning of living. Now let's briefly concentrate on the necessary goods and services. We do understand under this category the utility value, utility benefit that lies under it. We can categorize them under food, drink, clothing, accommodation, and education. Important is that the requirement of necessity for the minor appears at the moment of sale and or delivery. This was established with the case of Fawcett versus Smithurst. In this case, we have an establishment that the contract is binding for the minor if there is genuine utility benefit for the minor. Now let's talk about situations where minor keeps holding the benefit from the contract. They are holding the goods, and the court has the right in this situation to order restitution. Of course, if it is equitable and just. Also, in similar scenarios, the minors cannot be sued for price. This means that the minor cannot be enforced to pay for the goods and services. And also, when after the restitution, when the values are returned, those can be returned in the condition that they are found in. So there are no requirements of the condition which are enforceable against minor. Now let's talk about the property and whether the property and real estate can be under the legal title of minor. The minors can usually have a beneficiary interest for property ownership. So via trustees, they can have beneficiary ownership, and this equitable interest is always the main option for the minors. It means that they cannot have legal title for the property and they only act through trustees. What we should do if minor has already paid under the contract or transferred a property. Can we think of a scenario where the other party can request the payment or the property to be returned? Basically, restitution in case of minor is holding the property. In this case, we need to talk about complete failure of consideration. The minor should provide the evidence, there should be provided an evidence that there was no benefit for the minor through this agreement. There is the case of Stonebark versus Scholar, where we have the minor who wanted to purchase shares of a company. She successfully purchased the shares, and afterwards she wanted to cancel the agreement, but she was not able to get the full refund for the agreement because she has already received a value in return. Now let's talk about again the point of the restitution, where there is still the benefit which is which is being held by the minor, and the other party tries to order restitution in order to eliminate the enrichment. The other party does have right to do this even if the contract is not enforceable, if they are providing enough evidence that this is unfair, that the minor keeps holding the benefit. So we have covered basic level of capacity, especially concentrating on the minors area. Now let's try the perspective of legal tech. I would like to concentrate on the family offices, where it is common for minors to have shares, real estate, or equitable interest of any property. They usually cannot have the legal title for the property, and everything is managed by trustees. So this gives us a good stage to set up legal tax solutions, such as for corporate housekeeping, in order to have equitable interest tracker, which will be a centralized dashboard to track equitable interest for beneficiary owners. And we can imagine having the metadata of minors, including their date of birth. We can include also relevant terms and conditions for the beneficiary ownership, and also any information regarding the relationship with the trustees. And as soon as they reach 18 years, the event trigger will flag various conditions, which will then automatically trigger the transfer of the shares from trustees to beneficiary. This is, of course, a very specific example, but this gives us the understanding of how the capacity management can overall be scaled with legal tech. Thanks for watching, and see you in the next episode.